action. Okay, the first one, when you think to make a patent application, when you decide, okay, I have to make a patent application, what is the first thing that you do? What is the first thing that comes into your mind? See this question? Like, the first question should be like, why should I patent this? You can give me the answer. Why should I patent my invention? Which one is more advantageous, a patent or a publication? Which one should I prefer? Patent? Why? Why? So you mean to say that you don't have any right over your publication?
You have a right, but you protect it from other people.
Very good. Yeah, very good. Okay, that is right. So you protect. So you get some sort of protection. You get some sort of legal protection out of your invention, right? That is not given by the publication. I do not want to say that publication is bad. It is not like that. Both has got its own pros and cons. You cannot compare actually for publication and patents. Being research scholars, we all love to have a very good publication in very good impact factor journals, right? So what is the clause that you can opt? First one, which one you should go first, a patent or a publication? That is the key thing that you should carry in your mind. How many of you are research scholars? Majority, okay. So, suppose that we have a very good potential invention with us, and so I have two options. My mentor has given me two options. You can either opt publication or you can go for a patent. Which one? You should. Which one? Patent. Is that an honest answer? When I was a research scholar, I was after very good impact journal publications, not after patents, because at that time I was not aware about it. That is the thing. Okay, you mean to say that you opt patent? Okay, very good. The thing is that, okay, you do one thing. First, you file a patent application, you make a patent application, at least a provisional one, and maybe the next day itself you can go for publication. Alright? But first thing should happen with the patent application. First thing you go for patent application, get the patent application number from the patent office, and once when you get this application number, the very next day you can file your journal article. Alright? So that should be there in your mind. Okay, the next thing. Okay, I'm ready with the invention and all the details, technical details. So which one should I go for? A provisional one or a complete specification? Provisional? Okay, what is the basic difference between a provisional and a complete specification? Provisional?
Will be valid for some time.
Yeah, okay.
Before completing the work.
So, imagine we are in this stage, like I have an idea with me, but I'm not sure whether it would work or not. For that I have to carry out certain sort of experiments, but at the same time, this stage I need to discuss this invention with somebody else, which I don't trust him. But at this point I need to get some opinion from him as well. So in that case I need to get some sort of protection. So that time you can apply for a provisional specification. Alright? Yeah. So once when you apply a provisional specification, you need to file complete specification within 1 year of making the provisional specification. So you have only 1 year time. So you have to complete all the experiments by this 1 year, then you have to go for complete specification. So accordingly you need to plan which date you are going to or which time you are going to file the provisional specification. Alright? Okay.
So that date is called priority date.
Yeah, the date of filing is the priority date, the first time when you make an application. Whether it be provisional or sometimes, okay, another question comes here. Is it possible to file directly the complete specification without making a provisional one? Yes, you can. Okay, it is not mandatory to make a provisional one. You can directly go for complete specification. In that case, the priority date is the date of filing of complete specification. Okay, and then what is the next question? Alright, and when should I patent? Is there any ideal time for making a patent application? What do you think? What time of your research?
Even when you have idea
Okay, in the ideation stage, in the idea itself she is saying. Any other answers? I would say not too early, not in the idea stage, not too late. Yeah, somewhat in between, the middle. That is the ideal time to file a patent application. And where should I patent? In India, in US, Canada, on what basis you make this choice of country?
Depends on the product.
Products,
Where I,
use,
Application.
where I am going to manufacture.
The easiness with which we get.
easiness of getting a product.
No, not like that. The different countries are having different rules.
Huh.
So if it is too straight, it will be the chance of getting.
The patent is significant. That is true. But it is not with the patent.
Where I am going to
But if it
manufacture and
is,
sell.
India is the strict country. You know, getting a patent in India is much more difficult than in US and in other countries. India is going to be difficult.
Where I am going to decide to manufacture and sell. Right?
You have already decided where you should manufacture. On what basis you have actually decided where to implement your manufacturing?
Based on the demand and market of that
Yeah,
area.
exactly. That is based on the demand or the market. So first ideally you should make a market search and understand the major markets in the country. So based on that you can actually choose the countries, whichever jurisdiction you want to file. Otherwise it's going to be much complicated. Okay. The last question, this you might be knowing. For how long should I get patent protection? 20 years. Again, my question is, from where this 20 years counting starts from?
Filing.
From the date of filing. If you are making a provisional specification, see, that starts, the 20 years start counting from the date of filing. The first one, the provisional specification. Okay, the first question I don't want to ask, what is a patent? Yeah, what is the definition? You will have definition of patent.
A complete product or a process newly created.
Newly created, for that you get some exclusive rights or some legal rights.
Legal protection.
Legal protection that you get over the invention. So we have different definitions. Okay. So this is the definition according to the Indian Patent Act, which I am not going through. And as the previous speakers have already pointed out the eligibility criteria of the patent. Alright, you have repeatedly you were hearing the same thing. Like these three elements are like the three strong pillars of your patent application. What are the three? Yeah, and industrial utility, industrial application. So if these three elements are very strong, your patent application is going to be very strong. No doubt on it. And the first one, patentable subject matter. That is also, she had explained it very beautifully. Like patentable subject matter. As per Indian Patent Act, we have a separate section that handles clauses for non-patentable subject matter, which means that not all the subject matter under the sun is patentable. There are exclusions. So when you make a patent application, be sure that your application is not falling under the ambit of the clauses of section 3. Alright? Yeah. Okay. So patents are majorly granted or given granted either for a product or for a process, or sometimes it can be granted for both process and product. Okay. The next question. I have so many questions all through my slides. Only questions I think. Okay. So any preparation, should I do any kind of preparation before drafting or making a patent application?
Yeah, definitely.
You should. Okay. What are the preparations?
The claims need to be strong which we actually file it.
Okay, so before coming to claim and all, because you might have filed a patent application, right? No, but still you know a fair idea regarding patents.
No, maybe the idea how we need to put it and also how that all the three key points need to be focused in.
Yeah, imagine that this is a stage where you have almost completed your invention and where you plan to take it ahead for a patent application. That is the stage. No, we are not in an ideation stage. So what are the preparations to be made from my side before making an application?
No such patents are available, like my idea center, we know.
Yeah, exactly. So So that is there, and before making a search, or she is coming to search. So before making search, the first question that arises in my mind is that what are the information? If I am filing it through a patent agent, what are the information? So how it can be drafted? That is the first question. Whether it should be drafted by myself or it should be given to an external agent, like a patent agent. So if it is through a patent agent, what are the information that is to be given to the patent agent, right? So the information should be there. Okay, and the next question, sometimes you may have other questions like whether I should have a prototype or a working model at this particular stage. So all these questions, some sort of questions you might be having in your mind. So it is where you need to understand the importance of invention disclosure form. Have you heard about IDF? Yeah, invention disclosure form. So using this form, you are actually disclosing your invention to a patent agent. Alright. Yeah, in other words, you should be, or in other words, when you give this information to a patent agent, the patent agent should be able to stand in your shoe and understand your invention completely. Then only he can draft in such a way to give maximum protection to your invention. So please do not hide any of the aspects of your invention from the patent agents. Okay? Yeah. Okay, these are the things to be covered when you make an invention disclosure form. See, it should have a description. It should have a clear description of your invention. We should understand about the clear story of the invention should be there. And the second one, the description of the problem. What is the exact problem that you are trying to solve? Okay, and you have a problem, and definitely for that you have a solution. So you need to state both problem and solution. And what is the working of the invention? What is the exact working? How does your invention work? That should be given precisely. And of course, it should have a utility, that is the industrial application part. Alright, without industrial application, if your product is not having any utility, that will not be considered for a patent. Okay, and then what are the advantages of the invention over the others? Obviously, you will be having related existing other inventions. So what are the advantages? What are the advantages of your invention over the existing ones? And you describe if your invention, if your machine, say for example, has got different components or elements, you need a description of each and every elements. Alright? Okay. And then if drawings and sketches are applicable, that is to be given. The last one, if it is speaking about some sort of improvement of the existing one, then you have to clearly distinguish it from the closest or the earlier existing prior art. So all this information should be there in your invention disclosure form. Okay. So you all are aware about patent search. So imagine that we have made this invention disclosure form. We have already submitted invention disclosure form. So what is the next step? The next step after submitting invention disclosure form, are you going directly to filing?
Novelty search.
Novelty search. Okay. So before filing, so we need to make sure that your invention is novel. It is not existing anywhere. Okay. Novelty you have to prove. And about the inventive step, again you have to make sure that your invention has got a solid inventive step. So for all this, to cover all these aspects, we do a proper patent search. Okay, so this is like, yeah. So I'm rushing up. So these are the databases. She has already mentioned. We have paid databases and we have free databases available which you can use for extracting the prior arts. You can give different combination of the key features of your invention in these databases, and you can pull out the existing related prior arts. And you will clearly, when you get the prior arts, you will clearly understand the gray area of your invention. You will be able to distinguish the difference between your invention and the closely existing one. Then you identify the gap between these two articles, and that gap should be utilized for framing your invention. That is the ideal thing. Okay, so see, we have the free databases as already we have already explained. We have Google Patent, that is the most simple and user-friendly one. Again, it has got its own disadvantages, which I am not going into the details. So you can simply use Google Patent. You can simply type it in the Google, so you can easily navigate to Google Patent. So you can give the relevant information. If you have some sort of informations like the inventor, applicant, or you have a patent number, all sort of informations can be used to pull out the prior acts from the Google Patent. And again, we have USPTO. This USPTO is United States Patent and Trademark Office. Again, we have an Indian Patent Office website. Okay, you can go to Indian Patent Office website and extract Indian patents. So most of the Indian patents are, from my experience, when we look for Indian patents that are missing in Google Patent. So it is ideal to go to Indian Patent Office and search. Again, that website is also not a complete one. So we advise you to we would like to recommend you to use a mix of all the databases to come up with a good search report. And eSpaceNet, the problem with eSpaceNet is, it is not a problem, but only the European patents are available with eSpaceNet. Okay. And we have the databases like the Vent, Pathbase and all.
How much expensive?
Which one, sir? That comes from 10 lakhs and it starts from 10 lakhs. Usually. Okay. Anyway, you don't have to worry about the free databases. At least you make some search with the free databases and make a professional search if you want.
If I want to protect an idea in India, it's already a prior, it's already existing in US. It's possible to do in India unless that inventor is going to.
See, it's already existing.
Yeah.
It's already existing in US. So that your idea is already there in the public domain. Yeah. Yeah, so that is
manufactured here, so I want to get
yeah, that can be done. Yeah, you have to take permission from that person.
Manufactured in India.
If you want to manufacture in India also, you need to take permission because that is the purpose of giving patent. Okay, so
just 1 second. Regarding the search report which you have asked, I think in the chart where we have actually explained to you that once we connect you to the patent agent, okay, that initial discussion, before we take the permission of the university, in our case, okay, for Kerala University's case, before we take the permission of the competent authority to go ahead with the patent application, we do get in touch with SCTIMST. They do run a patent search analysis and then they do give us the information. And there are charges for that. And that is something that is borne by TRIC in the Kerala University. So you people don't have to worry about your search report analysis because that is also covered by TRIC. Okay, so the only thing is that you come up with your presentation, your ideas, and then you approach, and then you get everything done. It's actually a package. But then it is always good to know what are the charges that is also there. Yes, thank you so much.
okay, so we are moving to filing process. We have completed search. The next thing is that we are going to file it. Okay, the first thing we are going to file a form 1. So once when you fill a form 1, you have to be very, very careful. Okay, you should be able to clearly distinguish an applicant and an inventor. Clearly understand the difference between an applicant and an inventor. See, I usually take this example. Say, for example, a group of 5 research scholars from Kerala University making an invention in the Kerala University laboratory. Okay, there are 5 research scholars involved in this, and the invention is a really good one. So who is going to be the inventor and who is going to be the applicant? Now the system is very much clear to them who is going to be the applicant and who is going to be the inventor. So who is an inventor?
Who is a part of that?
What makes them? What makes them an inventor? The idea? Whoever came up with the idea, obviously, they are the one who had made the intellectual contribution, right? So they are the inventors. In your case, the research scholars along with the research guide, the PA, they are going to be the inventors of the application. Okay, then why you said that the applicant is Kerala University? Why?
We are the authority
We are
who
using the facility.
work with the patent.
Can't you file your own?
Filing process is
Yeah, why? Because the system runs like this. Other than that,
charges.
it is not because of the charges that they are
Based on the resources which we utilize.
Yeah, exactly. You are utilizing the resources from Kerala University. They might be having, your PI might be having grant funding from a central agency. Alright. Yeah, so this is a cumulative effect. So the applicant is going to be the Kerala University. An applicant is nothing but a person or an entity who has the right to file the patent application. So in your case, this is Kerala University. Okay, so sometimes we get inquiries of addition of inclusion of additional inventors. Once a patent application or once form 1 is already filed in the patent office, we get queries. Can we add an additional inventor into this application because we believe that he has made some contribution on this. Is that possible too? Because recently we got 1 or 2 cases asking for adding inventors. First of all, yes, it is possible, but it is not a simple process. So once when you make a patent application, please be sure that who all are the inventors, who all are going to be the inventors. So that part should be clear from your side. Okay, and there are 2 scenarios where we can add additional inventors. The first one is going to be simple for us. See, so in the first case, you can see an applicant and a claimant. Claimant to be an inventor. There are 2 persons. These 2 persons, applicant and a claimant to be an inventor. He claims that he is an inventor. Both of them together appear before a controller. And the applicant says that, I believe that this person has significantly contributed to the invention, but somehow I missed his name and I want to incorporate. I want to add his name in the application at this stage. So jointly they are making some application. So in that case, okay, since there is no conflict of interest, it's going to be pretty easy. Okay, so that is possible. See the second scenario. What is happening here? There is no applicant. It is without the knowledge of the applicant. The inventor himself appears before the controller and says that, see, I have made contribution. I have significantly contributed for the development of the invention. Without me, it is not possible. So I want to claim my inventorship. So is that possible? There is no applicant in this picture. So there is no Kerala University, say. So what happens in that case? Yeah, the controller will give notice. The controller will send notice to the applicant and all the other concerned persons and notify them. So this is the case that is happening here. And if possible, he will ask them to appear for a hearing. Hearing is nothing but a kind of discussion between the controller and the interested parties, and based on the hearing, he would agree or not. That is strictly up to the controller. So all these things are going to be legally very difficult. So again I want to emphasize, please be sure who are going to be the inventors from your side.
One question. Suppose the product is actually giving a company or some other institute, and we are actually arranging ourselves in the Kerala University, and then who will be the inventor?
So for that you need to make a discussion with the company, and you should enter into an agreement between you and the company who all are going to be the owners of your IP. That you should decide between.
What about the institute? Like research institute?
You can decide among yourself who all are going to be the inventors. You should have a policy. Yeah. Yeah.
That you should define who should be the applicant.
Yeah.
Whether you allow inventor to be an applicant, make that into the policy. Okay, institute and university both, inventor and university both can be. Or female applicant, there is an experimental process. For that you can make. Okay. So apply inventor as the applicant, and then you can for when you want the name of university, because university there in the law. And consult a patent agent. Not make a decision on your own and make a mistake of
measures that one will take more.
No, nothing like that. Nothing like our publication. There is no such thing called first order or second order. If there are 5 inventors there in a patent application, all of the 5 are given equal rights.
Ma'am, one question. If anyone asks me like you have a patent, so it is registered, the applicant is another company, can I claim that I have a patent?
Yeah, you can claim. And nowadays, for this kind of cases, they are providing a certificate of inventorship. So you can separately apply for a certificate of inventorship from the patent office, and that is a very good evidence.
Along with that granting, or
It has to be applied separately. Otherwise, in worst cases, you can take the Form 1. In Form 1, they can mention your name. So that is the only evidence. Okay, I am not going into the details of the complete specification. I think Sir will be discussing all these aspects in detail in afternoon. So these are the components of the complete specification. That is when you make a write-up to submit it in the patent office, all these components should be there. Alright? Yeah, next slide. So ma'am has already defined what is a patent infringement. What is a patent infringement? Patent infringement, your patent has been taken, it has been stolen. So your rights has been stolen, right? So in that case, what can be done? Patent. It is not patent acquisition. See, somebody is infringing or somebody is using your invention without your permission. Somebody is making a product using your technology that is mentioned in your patent. But the thing is that you have got legal rights in the form of patent. So once when you have a patent and you notice that it is infringed, you have the right to file a suit in the court. Alright, then what will do? You will be granted relief for the infringement. So such kind of options are not there with the publication, right? So you can ask the relief in terms of in the form of damages, injunction, or a kind of profit. So the next few slides, 2 or 3 slides are exclusively for those who are coming from biotechnology background. Who all are there from biotechnology background? Life sciences. Oh, okay, all right. Okay, next slide. Okay, when you make a patent application, suppose you are using some kind of biological material. Okay, you are using some kind of biological material like a plant product or a plant farm you are using. So in that cases, along with patent application, you need to get NBA approval, that is National Biodiversity Approval. So you have to apply for NBA approval separately through different channels. So when you make an application for NBA approval, you need to disclose the source. Where have you been obtained? The source of the biological material along with the geographical origin of the biological material. That is going to be the mandatory part of your application. Okay, they have already mentioned this is the clauses, the non-patentable clauses applicable in the field of life sciences. It is not only for biotechnology, we can put it as life sciences. So as per section 3C, see discovery of any living or non-living substances. Say I have discovered a new plant species or a new frog species. Am I eligible for a patent? No, you are not, because it's already there in the nature. You are just refinding it or you are just finding it out. So with the same clauses, what is happening with gene patenting, see? So you have found out a particular gene that is responsible for a particular disease. Okay, it's going to be impactful in the society. So can it be patentable? The gene sequence you have elucidated. No, why? Because it is already there, right? It is already there. You are just finding it out. So with the same reasoning, it is not going to be patentable. Alright. And section 3J speaks about the same thing. Plants and animals in whole or any part thereof cannot be patentable. And the claims, see the next part. Claims relating to essentially biological processes of growing plants, germination of seeds, or developing stages of plants and animals are again objected. Okay. Yeah, section 3I, you have already seen this. We do not have any option, unfortunately, for patenting any methods, any diagnostic or therapeutic methods for the treatment of human and animal. If you are finding out a new innovative method for doing surgery, again that method is not going to be patentable. But the device which we use, the device that you use to perform surgery, the robotic arm, which can be the devices, they can be patentable. They are considered as the product. Yeah. And 3E, last one, section 3E. So it prohibits patenting substances obtained by mere admixture unless they exhibit a synergistic effect. What does it mean? Combined effect, additive effect is not allowed. The additive effect is not allowed unless and until you prove the synergistic effect. Say for example, you have 5 plant compounds. Okay, all the activities. The activities of all the 5 compounds is already known. So how can we make it patentable? So already we have 5 non-plant compounds with us. Already the activities and the MIC values and everything is known. So you should be able to show some synergy. You should be able to demonstrate that it is not mere because of the additive effect. Some unexpected thing is happening when we combine all the 5 compounds so that we get a synergistic effect. Okay, and you need to
application, and if the same component has application in another applications, and there is papers are there, is it okay?
Yeah, that is okay. That, for example, we have so many compounds we are using in that way. Say for example, chitosan. We are using it for thousand applications, right? Especially in the medicinal field. Yeah, we are using it. But the thing is that you need to think in what way you are writing, in what way you are demonstrating your product. Okay, next slide. Okay, again, section 3B, Nimisha has already said, like in India, method of cloning, not only in India, in US also, the method of cloning of human is also not patentable as per section 3B. Okay, we're going to the last sentence. And so we have already discussed about the gene sequence. And imagine we have come up with a sequence where we have modified it somehow. So we are modifying the gene sequence in such a way that it can use or it can make it for a new application. So in that case, is that going to be patentable? I have made some modifications with my own thought process. I have used my intellect in modifying the gene sequence. So in that case, it is not existing there, right? Yeah, so there is a kind of human intervention. So those cases are patentable. And again with the case with microorganisms, the last one, microorganisms. Is that patentable? Microorganisms, if you find out some novel species of microorganism? No, it is obviously not. It's not going to be patentable. And then if I am genetically modifying this microorganisms, yes, in that case, it is going to be patentable. Yeah, and one more thing in case of biotechnology again, if you find out some new species, or if you are doing some kind of genetic modification with a particular species, so before making a patent application, you need to deposit the strain. Okay, you need to deposit the strain with Indian repositories, like MTCC, Chandigarh. Then you will get an application number from there. You will get a reference number for the submission. So we can apply a patent only with this reference number. That is very important. Okay. So this is the last slide. So which talks about the innovation cycle. So this is the overall takeaway. So what is happening? Everything starts with doing some kind of R&D research. And so out of your research, you have made some invention. So that is being disclosed in the form of idea or patentability evaluation report. And then we have an assessment. Assessment of what? Assessment of novelty, inventive step and everything. So that will be assessed. Once it passes these steps, once when we feel that, okay, it has got good novelty and inventive step, we can take it ahead. So the next thing is to find out appropriate intellectual property. If not patent, what are the other types of intellectual properties that can be applied? Okay, so we were talking about software patents. So in India, we said like software patents are not allowed. So in that case, what can we do? So you can go for like copyright. So in that sense, okay. And then imagine that you are awarded with a patent. Is the story ends there? No, actually the story begins there with the grant of a patent. Okay, so it has to be marketed. You should find out the market potential. You should be able to commercialize your patent. You should be able to find out some companies, or you can start your own startups, and somehow it should be commercialized. Okay. So with commercialization, we are actually making money. We are monetizing it. Yeah. So with this extra income that is coming out of the patent, you can invest again and again in the R&D, and then the cycle continues. This is how it benefits the entire society, and this is how our economic growth happens. This is what patents meant to be. Okay. So this is the last slide. So is there any other questions? You are all very hungry and tired. Okay, let us stop here and